A warm welcome to Honorable Chief Justice Jayant Banerjee and the other speakers for this session. Good afternoon, everybody, and welcome to the fourth panel discussion of the ADR Bengaluru Week 2025. This session focuses on an increasingly vital component of India's dispute resolution framework, pre-institution mediation. With the move to the mediation, arbitration, mediation, arbitration, and similar other models across institutions and ad hoc arbitrations, a similar model in the judicial process is not only a welcome change, but a potential avenue to reduce the burden on the courts and consequently the pendency of the proceedings. As many of us know, the Commercial Courts Act 2015 and of course the more recently the Mediation Act 2023 have firmly placed pre-institution mediation at the front line of dispute resolution in commercial matters. The intention is of course clear: resolve early, resolve effectively, and resolve amicably, and then move forward towards litigation or arbitration. Yet, despite this legislative push, the system faces several potential challenges. And when done right, pre-institution mediation reduces costs, preserves business relationships, strengthens relationships between the parties, unclogs courts, and promotes a culture of collaborative dispute resolution. Strengthening this mechanism is not just a procedural reform, it is a structural necessity for India's justice system. That being said, it's my honor and privilege to introduce our distinguished panelists for today. Honorable Shri Justice Jayant Banerjee, Honorable Judge, High Court of Karnataka. Justice Jayant Banerjee brings over 2 decades of legal experience and a steadfast commitment to upholding the rule of law. With his recent transfer from the Allahabad High Court to the Karnataka High Court, his presence reinforces the bench richness of experience, especially in civil jurisprudence. Known for his analytical rigor and measured approach, Justice Banerjee is respected for his ability and to navigate complex legal issues with clarity, discipline, and a deep-rooted sense of justice. Justice Banerjee is the president of the Bangalore Mediation Center, and we fully believe that under his guidance, the court will effectively promote and use pre-institution mediation as per the letter and spirit of the law. A very warm welcome to you. Next, we have Shri Arun Kumar, Senior Advocate. Shri Arun Kumar is a seasoned litigator with 20 years of experience. Mr. Kumar is one of the founding partners of Press Law Partners, one of Bangalore's most prominent litigation firms. He was designated as a senior advocate by the Karnataka High Court in 2018 and regularly appears before the courts and tribunals across India. A very warm welcome to you. We are also honored to have Ms. Lakshmi Iyengar, who was designated as a senior advocate by the High Court of Karnataka in 2018 and who has over 27 years of practice before the High Court of Karnataka and the Supreme Court of India. Ms. Iyengar has appeared in matters before the Special Judge for MPs and MLAs under the Prevention of Corruption Act, Enforcement Directorate, National Company Law Tribunal, NCLAT, DEC Tribunal Tribunals, and the Appellate Tribunals. Karnataka State Administration Tribunal and Central Administration Tribunal and arbitrators. Ms. Iyengar is also a strong proponent of mediation and actively engages in promoting mediation and other forms of alternative dispute resolution. Very warm welcome to you. We also have amongst us Shri Aniruddha A.S., Associate Partner Lakshmi Kumaran and Sridharan. A.S. Aniruddha is an Associate Partner in the Commercial Disputes team at the Bangalore office of the Lakshmi Kumaran and Sridharan office. Mr. Aniruddha primarily deals with commercial litigations and subject matters such as contractual laws, mercantile laws, consumer protection laws, labor and employment laws, property laws, insolvency and bankruptcy code, etc., and has represented various public and private sector entities, including individuals before the Karnataka High Court. He also appears before the civil and commercial courts, criminal courts, NCLT, DRT, and other tribunals in Bangalore and across Karnataka as well. Very warm welcome to you. We also have Ms. Lakshmi Menon, advocate. Lakshmi graduated from the National Institute of Advanced Legal Studies in 2014 and went on to obtain her Bachelor of Civil Law degree from the University of Oxford in 2017 as a fully funded Commonwealth Scholar of the British government. Lakshmi represents a broad range of clients from the government, industries, and academic sectors, amongst others. Trained arbitrator, Lakshmi is affiliated with the Center for Online Dispute Resolution and has completed the FICCI Master's Trainers Program in Insolvency Law. In recognition of her contributions, she was honored with the Emerging Women's Leader Award by the Bangalore Chamber of Commerce and Industry, July 2021. Lakshmi serves on the Executive Council of Address Now as an online dispute, which is an online dispute resolution platform, furthering her commitment to innovation and leadership within the legal field. We thank you all for joining us today and taking your time out. Before we move on, and I let it over to the panels, we are doing the question answer session for this particular session slightly differently. We have volunteers across the auditorium with a notepad and a pen. We would request members in the audience to please write down your questions and pass it on to the volunteers, and we will give it to the speakers here. Thank you.
Warm welcome to all of you. I'm really glad to be amongst you all. I've been asked to chair the session. So we have an eminent panelists here. We have, of course, Mr. Arun Kumar, Senior Advocate, Ms. Lakshmi Iyengar, Senior Advocate, Mr. Anuradh, yes, he's an Associate Partner of Lakshmi Kumaran and Sridharan, and of course, Ms. Lakshmi Menon. I've had the privilege of having some of the advocates here appear before me, and I can well gauge from the standard of the arguments that are advanced by them that we have amongst the best of the advocates available here, best advocates in the country who are available here. So, as Mr. Siddharth Shankar Rai once commented, this was a comment made by, he referred to a comment made by a judge of the Supreme Court when the redoubtable Pandit Kanhaiya Lal Mishra of the Allahabad High Court was addressing the court. He said that please come to the Supreme Court more often. When you are addressing the court, the level of our judgments go up. So the level of the conversations here will go up because of these distinguished panelists whom we have amongst us. So without further ado, we will proceed. I would request Mr. Arun Kumar, Senior Advocate, to kindly lead.
Thank you, sir. So the topic for this evening is strengthening pre-institution mediation. At the outset, I must point out that I have certain reservations about the manner in which mediation presently happens, so you will probably hear the contrarian view from me. To start with, I think to get the process starting, I think we will start with the question of the question that I think most lawyers talk about today is about pre-institution mediation in, let's say, the commercial courts, and the concept of whether of interim reliefs that are being, when interim reliefs are sought, what happens, you don't go through the process of mediation, etc. So, Lakshmi, do you want to start that process?
was just checking the watch. A very good afternoon, everybody. And thank you to the organizers for having us over. Um, the topic that is before us today for discussion, like everybody here has already pointed out, including Justice Banerjee and Senior Counsel Arun, is a very interesting one because of the relevancy that it holds for us lawyers, especially those practicing on the commercial side. And now very soon, also the civil court practitioners. The way in which this panel would like to proceed with themes, so to speak, under this session is we have divided this into 4 sub-themes. Justice Banerjee leading us on what would be relevant for the sake of discussion. One is we want to touch upon what is the definition and scope of urgent interim relief within the context of Section 12A of the Commercial Courts Act and now under 89A of the Civil Courts by way of the Karnataka Amendment. Second, what we want to do is we want to talk about a little on the scope of Section 12A and the consequences of pleading an urgent relief where it is frivolous, not failed but frivolous, and what happens as a consequence, rejection of plaint, not refund of money, etc. And finally, we also want to touch upon the modalities of what currently exists and what can be better in terms of institution building, not just around the PIMs that happen vis-a-vis commercial courts, but elsewhere. And finally, whether there are best practices that we can adopt from across the jurisdictions that we are all familiar with. Now, on the first topic, my very, very loose thoughts, when we were doing this discussion internally, not rehearsed, we were just talking amongst ourselves to identify what all of us think about an urgent interim relief as. Anyone's guess, it's a very subjective issue. What may be urgent for you may not be urgent for me and may not be urgent to the Honorable Court. However, is there any benefit in defining urgency is one theme that we could explore. Like the Commercial Court Act has a definition for what is commercial matters. Would there be any benefit in defining urgency? And if there is, would then it limit the scope of discussion, or could it be broad guidelines, like an inclusive definition, but not exhaustive? That is one topic that we could discuss further. Second thing, when we discuss interim urgent relief that needs to be delineated before a commercial court for me to either skip the stage of PIM and directly go into court, or for various reasons that we use around strategy, the discussion that we were having, very interesting around these lines, is what is the relevance of linking mediation to only an urgent interim relief? Now, this is something to think about. All of us are familiar with the Mediation Act that just got notified. The Mediation Act now gives us 120 days to complete mediation from the time it's taken up. However, there can be suits even without an urgent interim relief where the final relief itself could be urgent. Therefore, I would rephrase Section 12, if it were up to me as a legislation, to also give room to any relief, not just interim relief, that could be urgent and that cannot wait for 120 days. See, even in a money recovery suit, if I were on the verge of bankruptcy as a person or as a company, and this money was so important and relevant to me, and if the object of the legislature is to encourage mediation in any fashion, why should it be linked to only interim relief? If my money recovery itself cannot be something that can come to me after 120 days of trial or 120 days of PIM and then an execution, therefore, one thought is to take away interim relief from the scope of urgency. The last thing that we could also speak about under the definition of interim relief is whether, like for instance, the recent judgment from Justice Alok Aradhe, where in an IPR context, the court has now set a bar for certain types of cases where there is a continuing scope for violation, where it is easier compared to other thresholds that need to be met where there are no judicial precedents or discussion so far, where that urgency can be then pled vis-a-vis the judgment to say, if it's a continuing case of IPR infringement, then of course PIM can be dispensed with. These are a few preliminary thoughts. I'd like to pass it on to the fellow panelists.
Okay, so let me give you the contrarian view without much ado. So I personally am of the opinion that the approach of insisting a mandatory pre-litigation mediation is probably not the right way of doing this, which is what is resulting in these various issues. Now the next stage is whether we look at urgency. What is urgency? Is that interim relief urgent? Now we have set up not only an excess amount of time will be spent in the mediation process. We have also, and nothing about this process makes people want to come and do mediation. It is simply a process of compelling someone to say that you have to go through these motions. You have to necessarily spend 120 days for no conceivable reason. You then have to, having completed this, if you want to circumvent it, now you are going to set up a whole new body of rules for this purpose. So it is my opinion, entirely mine, not of my fellow panelists, that the approach that we have to mediation, according to me, is incorrect. The mediation, as the very name suggests, is a process where two people are involved. It necessarily, you need to make people come and opt for mediation. To mandatorily send two people to a mediator and put him before a particular person is not serving that purpose, in my opinion. We could have, I think, in the earlier sessions, I think we had a discussion about regime of costs, and I think Aditya, who's probably not here, raised that issue about why is it that we don't have a regime of costs. Now, in my opinion, if a person institutes a suit without having recourse, having tried out methods of resolving it, not having opted for mediation, whether it is under the provisions. Now the new Mediation Act, of course, contemplates even private mediations. So whether it is an institutional mediation that is set up under the aegis of the court or the government or anyone else, or whether it is a private enterprise, etc. If a person does try it out, and there is an attempt that is made to avoid litigation, I think it is a factor that needs to necessarily be considered and incentivized in the assessment of costs. And as the sentiment that was expressed here earlier today, I am also of the view that the concept of costs is clearly what is lacking right across our judicial paradigm. If you look at, we have the judgment, I think it was Justice Ravindran's judgment, where he said, I think costs should be one which will ensure these results, but unfortunately the court came to the conclusion that because the statute does not provide for it, I will not interpret costs in a way in which it can lead to those results. And Justice Ravindran, I think in that judgment said, I will encourage the legislature to do so, but nothing further happened thereafter. If you look at the arbitration law, there is a regime of costs. And today, in the morning today, we heard very respected arbitrators saying, I am hesitant to use that regime of costs. And if you look at the Arbitration Act's regime of costs, it's a very nicely worded out costs because it includes all costs. It considers the conduct of parties. It takes into account the various parameters which we think is costs. It is not the Rule 100 of the Civil Rules of Practice where we say we will be paid 200 rupees for an execution petition. No. The arbitration regime for costs is a fairly good one. But we heard the senior arbitrators now saying, I don't want to go that way because I will discourage people from coming to arbitration. He says, I will wait till courts adopt this process for that to come through. Now, coming back to the issue of mediation, I think mediation is something, I think there's a famous quote by Fali Nariman. I think he has used it, and I kind of paraphrases many things that I would want to say. This is what he said. He said, mediation must stand on its own, its success judged on its own record, unassisted by judges. Now, mediation can't be a factor because somebody says, my case in court is taking so long, so therefore, now I want to reduce the burden of litigation in my courts, therefore I will push people to mediation. That's not mediation. It is telling a person that, listen, I can't give you relief. And really, in those kind of mediations, the persons who suffer are the persons who have already suffered, who have been at the receiving end of that litigation. It may be a tenant who is stayed over for years in a premises, not giving back his premises back to the landlord, or it could be a person who is, in motor vehicle cases, I think measurement of of compensation is to arithmetical accuracy today. Why is it that people have to come to court to ensure that this is done? What is, if an insurance company doesn't pay and forces the person to come to court, isn't there a regime of cost that could have taken care of it? Wouldn't insurance companies then try mediation and avoid coming to courts? So we need to encourage people to take mediation. But to say that I will put up a threshold and say that you will not be permitted into court until you go and spend 120 days, according to me, is a very wrong way of looking at mediation, is my opinion.
Good evening. I would agree with Mr. Arun on the factor of this 120 days. It's a complete waste of time, yes. But going by the factor that we would have to eliminate this process of pre and also decide whether post is required, let's just be practical. Right now, courts have held that it's mandatory, we need to go through it. So let's just find solutions as of now as to how we go about this process and then look at probably amendments at a later stage, because that's a long way to go. Now, if we do have a mandatory period that we need to go through, and answering Ms. Menon's question of also if that's mandatory, then how do we go about this urgency issue? So coming first to this mandatory, I think let's just be very practical. All of us go to courts. How does it work? Now, if you say that I cannot go and file my matter because I have not already exhausted the pre-mediation, then I think it's incorrect. So we should not have dismissals on the basis of the fact that I have not gone for my pre-mediation. I think we have a process in a lot of matters where the filing section doesn't give us a numbering, right? They tell us, come with so-and-so, or if you have paid your stamp or whatever, then I'll give you your number. In the High Court, this is how we go about. I think it should be the same. The filing is accepted, but number is not given, stating, exhaust your remedy with pre-mediation, and then get back, and then I give you the numbering. Because this eliminates the process of dismissal on the ground that you did not exhaust your remedy, then that person taking that up on challenge, stating that I did not do it in view of the urgency, and then we have these issues of urgency applications being filed, your interim relief being sought. Now, interim relief, again, that's a vast area. You want definitions to say what amounts to urgency and what does not. Now, again, that's a very, very large area to then define, because urgency in each area, for example, copyrights, urgency could be different. Recovery matters, urgency could be different. So how could you come up with guidelines on what constitutes urgency? So it's very difficult. So let's just have a very practical solution. I go to the court, I go to the counter does not accept it, asks me to go to mediation. So let's come to the next step. Mediation, again, so difficult. It's not as if I go to the mediator, I sit down and the other side's there. Unfortunately, the process is you need to give notice to the other side. That man's going to say, I'm not in town and so-and-so. These are my available dates. I will come on so-and-so. And the party who wants to file the matter is held captive till such time that the defendant's going to come to the mediation. So we need to formulate specific guidelines that if my numbering is not given, how many days am I given to go before the mediator? How many days the mediator give the other party to come before him to conclude it? So the mediator, he or she, informs the defendant, let us have all means of information taken on a record, for example, WhatsApp, email, telephone call, messages, all should be acceptable. Inform the other side that you need to be there. If you can't be there, you'll have your representative, and I'm going ahead with this pre-mediation on such and such a date. And after that, I will conclude it. 120 days, absolutely not. We need to have 1 week, maximum 2 weeks, because it's all a matter of trying to figure out whether you do want to settle or you do want to litigate. It's easily possible for the mediator within 2 to 3 sessions. Now, adjournments in these sessions also should not be after every 3 weeks, after every 4 weeks. We have back-to-back, maybe on an everyday basis or 2 to 3 days time given. The moment the mediator says mediation fails, the matter immediately comes to court. So what we've done is, then you get your numbering immediately. So you have eliminated this process of dismissal because there was no pre-mediation. You've eliminated an appeal stage for the person who did not get that interim relief on urgency. So you're quickly there within a framework of 1 to 2 weeks, and you start your matter. Now, once you start your matter, then comes the post-mediation stage, which we will probably discuss later. But to me, this is a very practical solution. And of course, we need not have these stages where, the mediator would, again, appointment of the mediator, we'd have to have a list. Now, Justice Banerjee, if we could make that suggestion on the mediators, if we could have these mediators, for example, magistrates always, when there's an urgency, the police takes the accused to the magistrate's house even in the middle of the night. All of us, when we have an extremely urgent matter, we move the Honorable Chief Justice in his residence in all urgency matters. So if we could have a list of specific arbitrators who are willing to be disturbed at a certain point of time if it's very urgent, and keep a separate list of mediators who would probably be available at a certain point of time, a list of mediators who are available at any point of time before the commercial courts. So in the commercial courts itself, a cabin is given where they go and meet up the mediator and the process begins. Or it could be in High Court, anytime on Fridays, because Fridays is when lawyers are free, mediators could be free. Friday evenings between 5 to 7, a room is given, and then that's how the process starts. So the moment this is done, then the...
You see, your question is understood, but this involves actually giving light to a larger melee that is there with regard to mediators and the system that is there existing. I would like to sum it up in the end. I will address your point that you have taken. I'll look into it. I'll address it. I'll try to address it.
So if this question
yes,
is answered, then
yes.
I think...
We can ask Mr. Anirudh.
Good afternoon, everyone. So just continuing from Arun sir's point about the question of pre-institution mediation itself. So I find in my view, there is a problem with the phraseology of urgent interim relief. That is to say, interim relief as we know it can include, is basically juxtaposed against a final relief in a particular proceeding. Meaning that the main proceeding will take a lot of time to conclude. You cannot wait till that final adjudication. Therefore, you want some interim relief. Now, when you are seeking interim relief in that context, it could include urgent and non-urgent matters both. So in that background, when the law says that you should be seeking urgent interim relief, it appears to suggest that there is a higher burden that you have to meet to be able to avoid the process of pre-institution mediation. So that may generate its own problems. So for example, let us say as the law now stands, under section 12A, you are seeking interim relief in a matter by filing an application. Also, you are filing a separate application seeking a permission of the court to avoid the PIMS process because you are seeking urgent interim relief. Now, that may lead to certain problems. That is to say, you are inviting the court to pass an order on one of these applications, which is urgent interim relief. Now, let us say a judge passes an order saying that I don't think your case deserves urgent interim relief. What is the implication? Does it also mean that somewhere without saying the other application where you actually sought interim relief, that application also has got orders passed upon it? Because it's a very thin distinction between saying that I don't think you deserve urgent interim relief, but having said that, your application for interim relief itself will be considered subsequently. So I think this problem stems in some way from the phraseology that is used, that is urgent interim relief, not to speak of the other issues that arise as to how do you define urgent interim relief in any given case.
You want to? Please do.
I would like to respond to Lakshmi's comments. Lakshmi laid out a entire process of how things needs to be done. I will stop there. I think that process itself tells us that this is a complex set of mechanisms that you need to put into place. Is that really the need of the day? What are we really doing? Every time we tell a person, we go through this rigmarole every other day. You want to file a suit, you will go file the form to start the pre-institution mediation. I'm certain in 90% of the cases, the defendants will not turn up because that's the very reason why you were driven to litigation in the very first place. You will spend another 120 days doing this. Now, coming to the question of urgency, which Lakshmi raised, and I realize I didn't touch that because I was more enthralled in giving you the contrarian view. On the question of what is urgency, now if you were to consider urgency, there is urgency in going to court. I need something today. Somebody is throwing me out on the road today. I need to be in court. Somebody is blocking my road, cutting off my water. There are urgencies which may be of today. There may be urgencies that are going to happen tomorrow. There may be urgencies that are going to happen next week. Now, if you have a pre-institution mediation of 120 days, then you need to contemplate urgency for 120 days. It is not sufficient that it is my today's urgency. Am I likely to have this urge? Is there something urgent that's going to come up in the next 120 days that I will need this relief? I will have to ask that relief today. You see the predicament in which I am? So if the urgency, if I today declare that I have no urgency and file the suit, and the urgency arises thereafter, or the defendant does something thereafter, I can't move court. I still have to go through that process. I have to get a failure report. Without that, I can't start the process in court. So I am blocked out of court by doing these things. And at the end of it, does it really result in two parties coming together? The very fact, see, if the system is going to incentivize the dishonest, then I think it is a wrong system. Now, in this case, if I was driven to court because of somebody's dishonesty, this 120 days is I sake for him. Because he knows that even the doors of the courts are closed to me for next 120 days. I have to go through this process. He will drag me through it. To the judgment that Lakshmi referred to. Now, if you look at the facts of that case, it was a IPR matter where the infringement had happened 18 months ago. The suit is filed 18 months thereafter. And urgency is pleaded. They say there is urgency. The court says, so no, sorry. This is 18 months ago it was infringed, so there's no urgency. You please go complete your mediation and come back. Now, it is in that context the Honorable Supreme Court says, no, when you look at this urgency, it is in an IPR matter, there will be urgency. If somebody is continuing to infringe your product, there is an urgency at all points of time.
With respect to the question number 2, how should courts determine what qualifies as urgent relief? Should evidentiary thresholds be raised? We did discuss this a bit, but I would say framework for one media to be present, and I would suggest this. We'll call it fast-track mediation, just like how we have fast-track courts, which go about in a different process, and then the suit is concluded in a very short time frame. So if we could have something called fast-track mediation, wherein this entire process is concluded quickly, we could go in depth into discussing that later. Should Supreme Court issue practice directions to create uniform standards on urgency and 12A compliance? Well, yes, but implemented, if you see, it has to be uniformly practiced, and it should be simple, guidelines should be followed, and if they're all in place, then with certain timeframes, it should sort the problems. Are litigants misusing urgent relief to bypass mediation? What safeguards can be added? Again, this is a very gray area. How do you determine what is misuse, what is actually urgent? So the courts will have to hear it. Once the courts hear it, again, the person who's aggrieved, if there's an interim order given, will again go up in appeal. So we are stuck within that first stage itself on what constitutes, whether it's urgent, whether it's not urgent. So safeguards, again, I just think if we just get done with the pre-mediation, mediation in a very quick manner and go ahead with regular interim reliefs that we do in any other case, that should sort the problem. Should costs be imposed on parties who falsely claim urgency to escape 12A? Costs could be imposed, but again, people are going to challenge that costs were imposed and again go and seek leniency from the higher courts. So that is something that should be looked into. Does 12A need statutory clarification to reduce ambiguity in exemptions? Well, not required if, again, we have fast-track mediations, it should sort it. Should commercial mediation be shifted from DLSA to special commercial mediation centers? I think if we have 2 centers and they're active, and we do have time frames, who are the mediators who are available throughout the day, which are the mediators that would be available in commercial court, which are the mediators that would be available in high court, which are the mediators that are available on weekends, and which are the mediators that could be troubled on an immediate need basis. If we could segregate this, this should sort the problem. What would a national commercial mediation authority look like? Now, that's a very vague question. It could be basically a cross of both arbitrators and mediators, but yes, I mean, that's what it could look like. Can scheduling be made more efficient through automated or hybrid platforms? Yes, absolutely. If you could draw out something as to how these formats could look, I think that could be implemented. Should parties be allowed to choose accredited institutions instead of being assigned to well, you were speaking about private mediations and all of that, but honestly, I think that then, again, it leaves room for taking more time, and then who would one party want to go to? Is the other party comfortable with it? All of that would arise, so I think we should stick to the list of mediators that are assigned. Should commercial courts supervise mediation centers to ensure timely completion? Well, commercial courts could just overlook and probably find out about, feedback, and also if the mediator could respond on a timely manner, I think that should suffice. Should mediators undergo domain-specific certification for complex commercial disputes? Domain-specific, yes. Certification process, yes. But that would require, I think, then formulation of who is the body that would probably determine this. So that's all a long-drawn process. So I think till such time that you do have domain-specific certification, you could have specific workshops conducted in the Judicial Academy for the mediators, specifically for commercial mediators, and also on domain-specific. So you could have mediators sitting down on issues which are area-wise that could determine all of it. In co-mediation, necessary for high legal, do we need legal plus technical experts necessary for high-value disputes? Now, legal plus technical experts then, if it is the NCLT format, absolutely no. Because we all know what we go through in NCLT, so absolutely no. Suggestion here is, if a mediator thinks this is too complex a matter, I think I need an expert. The mediator should have the liberty to bring in an expert, sit down with him and give him suggestions, and the mediator will decide. The legal expert is not going to be part of this process, and he's not going to co-chair. Do commercial parties prefer subject matter specialists over legally trained mediators? Now, I think legally trained mediators would be better over subject matter specialists because they do not know the legal area in which they could have it time specific. So I think legally trained mediators are better. Should India adopt a national mediation accreditation exam? Again, Ms. Menon, the exam is, again, you need to formulate who is the body who's going to conduct this. If all this could come into place, I think it's very well taken. What performance metrics should mediators be evaluated on? Mediators should be evaluated on their performance, yes. Statistics on how many matters they have been able to dispose of. Specifically on commercial arbitrations and mediations, their knowledge and of course, on how well they're able to manage both the parties in respect to whether the parties are able to, given their repose faith in the mediator, those are the areas which mediators should be evaluated on. Now, I've only completed 16 out of the 40, so I don't want to take on more time. If we do have time in the end, the balance 18 to 40, I will respond, but I think I'll hand it over to.
Well, the format of this certainly took a different turn, unexpected turn, because I had thought that the topics that were suggested by you all, that could be, each one could be dealt with one particular...
Each person did, yes.
Each person could have dealt with, but anyway, it has taken its own form, so to say. So, yes.
All right. Since we are doing this in our old Oxford-style debate, I can see Ashok smiling at me from last year's format. Actually, I just wanted to take a cross-section view from this room. How many of us would find mediation as a more attractive option if, like in arbitration, we could name the mediators of our choice? Because after all, it is a settlement procedure. Would you be more inclined to say that I want to name the mediator because I know my matter? I know that this involves, say, construction or shipping or marital dispute or any other commercial contract, and I know who is best suited to this. Maybe from a panel, maybe from a private mediator. I'm just looking for a show of hands. This is also indirectly a suggestion to the center. No, but absolutely, sir, absolutely. Point taken. But what I'm encouraged by is, I don't know how many of you noticed, Mediation Center director also raised her hand and said yes. Right. No, but the reason I ask this is because the Mediation Act also proposes for private mediations. And if there is a way in which we could marry the concept of a private mediator's settlement being acceptable to a court of law, so that in all our pre-institution mediations, the idea is to get an executable decree. Now, the minute you say that a private mediator of my choice, also now agreeable to the other side, has decided that we settle the dispute in a fashion, the enforceability of that should not come to question. The reason that we now prefer doing mediations, at least to my mind, through the commercial court in the form of a PIM before we go to a suit is only because it is statutorily required. If there was an option given to all of us, and this could become another line of profession itself. Think about it, because if you were to choose now a mediator of your choice, and then you would opt mediation, instead of even following the set format of a PIM, laying down all your evidences before the other side, right before the mediation itself, what standards of evidence would this be guided by? If all of this could be decided like an arbitration privately, and that itself became enforceable, that is a thought that probably is worth a little more exploration. The other item that I wanted to pick from what Madam Lakshmi on the other side with a Y suggested is that if now there is the availability of the mediator itself is a question, because logistically speaking, all of us who practice on this side of town, civil court, commercial court, high court, and only exception being NCLT, the current suggestion from across the bar, all my friends very vigorously nodding in support, is that mediation right now, Lordship, happens in the Nyaya Degula Center, which is where the family courts are located. If that could then be moved to somewhere center to town. Because what is happening is, most of the time, and we are to blame for this, lawyers are unavailable. Even if the client is able to make time, client is available on VC, and client is able to cooperate, both sides are present, even though the presence of a lawyer is not mandatory during mediation, because we are unavailable, we always tell our client, no, not today, another day. Then the mediator is not available. So if that could be kindly taken as a consideration or a suggestion from our end, and if that venue could be shifted closer to where the current courts are, because a lot of courts around them have space, we know that. And if that can be utilized for commercial mediations, I think it would make a lot of sense even logistically.
All right, so I think I'll take it off, I'll go forward from the question that came from here, to say, what happens if the other person does not agree upon the mediator? I think that really captures what is missing in our mediation. Mediation is by consent. Both parties have to come together to mediate. If they don't, it is not worthwhile considering it. It is, so you provide for mechanisms by which you make sure that it is, if they have gone through the process, they will suffer less in the litigation. They will invariably come and they will agree upon it because it is for them to agree. Now, but now look at the contra view. Now, if you don't have the freedom of choosing who the mediator is, now look at that wise. Now, you are compelled to go to an institution where they will allocate some particular mediator. The person may or may not be adept with that particular dispute. There are people of different levels of competency, and you may end up taking a particular matter which is beyond that person's competencies for handling. Now, the end result will be a failed mediation. Now, if there was this issue, if mediation was, made mandatory by virtue of making it stringent in the court process, without we pushing them upon some X or Y mediator, asking parties to go and find their own mediators, we wouldn't be in that situation. A couple of other points that Lakshmi referred to. She said discretion stricter. I'm not sure how I will understand the word stricter. I would say if a plaintiff pleads and says there is urgency, I think the court should just accept it as that there being urgency and give him the permission to do so. You can always, I think, send a person who has instituted the suit thereafter to mediation. Why should it result in the dismissal of a proceeding? So the ability to send a person to mediation can happen even after the suit has been instituted. Now, this threshold bar, and then saying, I will interpret it stricter, now I have to prove urgency, that is as good as arguing your application for injunction, I suppose. Because your injunction application will be pre-decided along with the application for urgency. So therefore, I would say, I would not agree with a stricter reading of the pleadings. I would say if somebody pleads that there is urgency, please give them the latitude, but send them back thereafter. Don't say you don't have to go at all. The other thing that I wanted to talk about was, I think Lakshmi spoke about mediation institutions. There is a provision under the new law for institutions and accreditation. Once the mediation council is set up, they can then register institutions and set mandates. Now, there are good training institutions in India. The camp is one of them. We have our own mediation center trains people in mediation. We have I think there's one in Kerala. I think it's called some Alex Center or something like that. And there are international training centers where people get trained for mediation. We set standards. I mean, we have set Bharat 5 standards. We have set standards for automobiles. We have set various standards. We can set standards for what is the minimum threshold to be a good mediator, and then certify them for being so. And I really don't see why this has to be done within the compound of the civil court or in Nyaya Degula or elsewhere. People should be permitted to do it in the leisure of their own boardrooms or wherever they are. Whether they want to do it online, they want to do it in person, leave the choice to them. But they should have attempted it. If they don't attempt that process at all, penalize them in a regime of cost, is what I would say.
Thank you to each of the panelists here. The matter has, as the discussion progressed, boiled down to the mediators, the location where the mediation should be held, when should it be held, whether the mediator should be asked to deal with the mediation on an urgent basis, whether he can make a part settlement in terms of a part award can be made, a part settlement can be made. And of course, whether one of the questions that was put by uh, Madam Lakshmi Iyengar was with regard to the mediator themselves. Now, one thing, of course, we all know that unfortunately, the Mediation Act has not been enforced in its totality. Mediation Council has been set up, but the relevant provisions, they have not been enforced yet. So it is, before it is, I mean, at the time of its birth itself, it is not being allowed to grow. Of course, there may be certain constraints that are involved. Here, we are looking at commercial matters all over the state. There is the Karnataka Mediation Center here, which I'm proud to be the chairman of that. And I see that the mediators there, they are a very dedicated set of mediators over there. And they have the ability to handle very complicated, complex matters. They have speciality in different fields. Many cases, most of the cases that are coming here are matrimonial matters. Several matters are commercial disputes that are coming. But majority matters are family matters. Now, this building, adjacent to this building, is a new building of the Mediation Center that is coming up. We will have, as per the plans that I have seen, it is going to be a state-of-the-art mediation center here. And Karnataka should be proud of such a mediation center existing here. And, but I would like to share with you certain figures. You see, we are talking about mediation generally and mediation, pre-institution mediation, particularly in a place like Bangalore. Now we have to see that what all commercial courts are there, firstly. Now, there are dedicated commercial courts and there are designated commercial courts. There are 11 dedicated commercial courts only in 3 districts. One is Bangalore City, the other is Bangalore Rural, and the third is Bellary. The majority of the dedicated commercial courts are in Bangalore City, which are 8 in number. 2 are in Bangalore Rural and 1 in Bellary. At present, that is on pendency as on 31/10/2025, in only these dedicated commercial courts is 5,851 cases, only in these 11 courts. As far as designated commercial courts are concerned, there are 49 of them in various districts across the state, including Bangalore City, Bangalore Rural, and Bellary. The pendency in these designated courts are 8,595 cases. Now, let us see what mediators are there. Fortunately, due to the 90-day mediation program that we held, that was Mediation for the Nation, many aspects that were lying hidden, they came forth. The fault lines were there for all to see. We found that though there were over 1,000 mediators who were registered, but actually the figure was much less. There is a serious dearth of mediators. Now, the Karnataka Legal Services Authority, they have their own schedule of fees that is to be paid to the mediators in the districts. And I don't want to comment on that. We have to see that what all infrastructure has been put in them, put in the districts also. It is a particular room has been designated in the ADR building in the district courts for, or wherever the ADR building is situated, for conducting mediations. Now, I have met the mediators over there. They are lawyers. They are not so affluent as with the lawyers that we see here. Please, we have to recognize that. Yet I see in them a fire. I see in them the dedication to work, and I found that they are competent mediators over there. Competent enough to handle commercial cases, but they are coming in their lawyer's dress. They wear it proudly. But we don't have the infrastructure, the wherewithal. We don't have that air-conditioned room. We don't have that boardroom type of a table. And this mediator tries doing his best over there. And the people who are coming from the corporate sectors, when they come in that situation, sometimes they get put off. That itself is a rejection to the system. So things we can discuss here, but they are of a very elemental level, that how deep we need to look at these things. And most of these cases, what is happening is, of course, the aspect of urgency has been raised, definitely. Infringement, my God, that has to be looked at immediately. There are so many cases that can occur. And it is not just that. Copyrights, there are a list of matters that are identified as commercial disputes in the Act itself. Now, transfer of shares, they are being dealt with there. Shareholding of a company, registered office, if it is here in Bangalore, of course, they have the facilities of the regular. Of course, now, of course, we may have to see that all online mediations are being permitted. So at the comfort of your boardroom, at the comfort of your office, you can have a discussion here. So location now has started to lose so much of relevance. All right. So that aspect may be there. Now, the Act Section 12A, that deals with the authorities who are mentioned under the Legal Services Act. They will be the authorities who will look into these aspects of appointment of mediators, who will be the mediators, and they will select them. But you see, we need to have that base of mediators. Of course, private mediation now, the new Act recognizes that, but we have to wait till it is enforced. To have a private mediation come to light and be acted upon. Otherwise, it will be just like a settlement entered into between parties. It can be there without the imprimatur of the court can be given at a later stage. But at the initial stage, they may have to go on their own. So it will not be under Section 89, but it may be under Order 23. So it can be an out-of-court settlement also, where they go, they take the matter to the commercial court, and the court gives its imprimatur to that. So that being the case, and I could have gone on and on, but the time is we have run short of time. So I would like to thank each and every one of you, the eminent panelists who are here, who have raised these issues that are concerning all of us. And I hope that the judicial decisions that come in the future, they will address these things, these issues that need to be addressed. Thank you so much.
I would once again like to thank Shri Justice Jayant Banerjee, Honorable Judge, High Court of Karnataka, Shri Arun Kumar, Senior Counsel, Ms. Lakshmi Iyengar, Senior Counsel, Shri Aniruddha AS, and Ms. Lakshmi Menon for their time. I would like to request Senior Counsel Mr. Sriranga to please come and felicitate our speakers. Thank you all for your time, and I thank the audience for your attention. I request the audience to please be seated until our dignitaries leave. That being said, our next session will begin immediately after this. So I request you all to please stay here. The next session will begin immediately, so please be seated.